Good afternoon and welcome to Lessons from the Past for the Future of Environmental Criminal Enforcement. My name is Chandler Randall and I am the Manager of Educational Programs here at the Environmental Law Institute, and I am so delighted to welcome everyone to today's program. ELI is proud to offer programming on cutting-edge issues in environmental law and policy, and it is such an honor to have you join us today for this special program. Throughout the program today, we will be taking your questions. Please submit your questions through GoTo's question box, and please do not wait until the end. Send in your questions as soon as you think of them. I would like to thank our outstanding panelists for joining us today to lend their expertise to this webinar. And while they will be introduced briefly, the full speaker bios are posted on our website at eli.org, and I would encourage you to check out their expertise and experience in more detail there. But as we begin, I would like to just briefly introduce today's moderator, Stephen Solo. Mr. Solo is partner at Baker Botts LLP, where he focuses his practice on business crimes, internal investigations, corporate compliance, security programs, and environmental, civil, and criminal litigation. He represents and counsels corporations and business associations regarding their legal and regulatory obligations, develops integrated compliance programs that address corporate and government expectations, and represents both corporate and individual clients in white-collar cases. Mr. Solo previously served as the Chief of the Department of Justice Environmental Crime Section, where he supervised more than 30 federal prosecutors and oversaw the prosecution of environmental criminal cases nationwide. Thank you all so much, and with that, I will turn things over to our amazing moderator, Steve Solo. Thank you all.
Thank you, Chandler. Thanks very much. And welcome to all of you. Greetings. Yes, my name is Steve Solo, and I'm so pleased to be with you all today. I took a look at the list of attendees for today's conference, and I can say with confidence that there are many in the audience who would do a great job on this panel, actually. So thanks to all of you for being here today, and to my panelists for participating, and my thanks to ELI for sponsoring this event, and for Chandler Randall for putting it all together and spending the time helping us to do this. We're going to focus our time on a few key areas, and I'm just going to mention them to you now. How collaboration with various agencies may be expanding the scope of environmental enforcement, how the whole of government approach to environmental justice by the new administration may impact both the investigation and prosecution of criminal cases, the ways in which environmental criminal enforcement has expanded, including to businesses outside the United States, what might be the impact of Attorney General Garland's recent statements regarding environmental crimes, some perspectives on the emergence of private equity in the heavily regulated industries, and the potential impacts of aging energy assets on the focus of government investigations. We'll touch on the uses of new technologies such as drones for investigations, and finally, time permitting, whether there may be some return to the use of what are known as community payments in the resolution of environmental matters, as well as expanded use of other remedies such as monitorships. The title of our talk is, Environmental Crimes Past, Present, and Future. And before we sort of dive in, I do want to take a personal moment to talk about someone who's no longer with us, Jane Barrett. Jane died this past April, and many on this call will probably know and remember her both from her government service, her private practice, and her work as a teacher at the University of Maryland Law School, where she graduated some years ago and joined the EPA, and immediately made her mark, helping to bring the one of the first ever criminal convictions in the history of environmental crimes. In 1981, she joined the Maryland Attorney General's office and headed up their environmental unit there. And then in 1986, she joined the U.S. Attorney's Office in Baltimore. And for the next 12 years, she brought some of the most significant environmental criminal cases in the country, including a landmark case against senior managers at the Army's Aberdeen Proving Grounds. In 1998, she left government and joined what is now Blank Rome. And for those who found her to be a tough prosecutor, they quickly learned she was an equally tough defense attorney, if not tougher. She was tenacious in that practice, but in 2007 returned to her beloved alma mater, University of Maryland Law School, to hold a role that I actually held before her as co-director of the law school's environmental law clinic, and a position she held for 10 years until her diagnosis with ALS, known as Lou Gehrig's disease. Jane was really a giant in this field, a leader who all of us on this call learned from and looked up to, and was also a great friend. And so I thought it fitting as we return to seeing each other and meeting together to remember Jane and to spend a little time thinking about her. We have a great panel today. I'm really delighted to be here, and I want to introduce them each to you. Sort of in the center here for me is Nadira Clark. Nadira is a partner with me at Baker Botts, where she represents both corporate and individual clients in a wide range of white-collar matters, including enforcement actions following major incidents. Nadira spent over 15 years in the Department of Justice before entering private practice, including serving as counsel to the Assistant Administrator of the Environment Division, as an AUSA in Maryland, and as part of the Office of Professional Responsibility. Thank you, Nadira, for participating today, and welcome. Also joining us is Stacy Mitchell. Stacy, well known to many of you, is a partner at Akin Gump here in DC, drawing on her more than 25 years of experience as a litigator in and out of government. She handles a range of complex civil and criminal litigation, represents clients on a wide range of environmental, regulatory, and policy matters, including climate change risk, environmental, social, and governance issues, and compliance assistance. In addition to having been chief of the section, Stacy served as the Deputy General Counsel of the EPA during the Obama administration, and began her legal career as a ADA in the best DA's office in the country, of course, the New York County DA's office. Sorry to the rest of you. Deborah Harris has been chief of the Environmental Crime Section since 2014. Prior to that, she was a prosecutor in the section starting in 1999, and before that served as a trial attorney in the DC Public Defender's Office. As an ECS prosecutor, Deborah was involved in the longest ever environmental criminal trial that I believe lasted about 8 months. She was one of the lead trial attorneys in that trial that ended in the conviction of both corporate and individual defendants, and sentences of nearly 6 years in prison. She also spearheaded the department's efforts to increase worker safety prosecutions, which resulted in the transfer of those statutes to ECS in 2015, a model that may repeat itself perhaps in the future in other areas. So our discussion today occurs in the context of a new administration that has made environmental enforcement an early focus. Just 6 weeks after his confirmation as Attorney General, as the 86th Attorney General of the United States, Merrick Garland took time to not only speak out in support of the Environmental Crimes Program, but to announce the creation of the first ever federal environmental crime victim assistance program. And his Associate Attorney General, Matthew Colangelo, speaking with the AG, noted that the National Crime Victim Rights Week fell on the same week as Earth Day. And finding that victims of environmental crime have received, in his words, insufficient support for too long, he further described DOJ and EPA's program to help identify victims of environmental crimes. So, Deborah, let's start there perhaps. And what does that mean for the environmental crime section and for your work? What will it mean to have an environmental crime witness coordinator, which I guess you do now have in your office?
Yes, the announcement was made. Well, first of all, thank you, Steve, for having me on the panel, and Chandler. The issues around victims have long been a focus for us at ECS and environmental crimes. We have had some big time litigation involving victims. For example, the BP Texas City led to a decision that was very important in this realm and probably led to the amendments that were made to the CDRA, as well as the WH Grace case, which dealt with the victims from the Libby, Montana asbestos trial. But on April 21st, the rollout of our new victim assistant program was made, and as you said, with the U.S. Attorney and the head of EPA, Michael Regan. The program is actually funded by the Office for Victims of Crime, and we now have a dedicated victim witness coordinator, whereas before we had to rely on whatever U.S. Attorney's offices we were working with, rely on their actual employees. But because of this, we can now ensure that victims are identified at the beginning of an investigation. We can make sure that they're notified, and we can make sure that they're treated consistently across the nation, as opposed to sort of a hit and miss and people doing what they think is right at the time. We also have, as part of this, we have the funding to do internal training, and we've done some of this in areas such as trauma-informed interview techniques and financial investigations to support restitution claims. And we also are doing stakeholder outreach, and we're a national resource for legal advice on the Crime Victims' Rights Act, so that people can come to us and get information. So I think it's going to be great. We've never had this, and now that it's up and running, I'm looking forward to using it.
When you say stakeholder outreach, what does that entail? What is the?
It's going to include, because of the emphasis that we're going to have on environmental justice, it's going to include reaching out to community groups and things like that to educate them on the services that we have, and along that line.
Yeah, you know, Nadir and I were on a panel with Matthew Tejeda from EPA, and he talked about community outreach as being actually the core of environmental justice. And it sounds like there's actually going to be some aspect of that centered in your program as well.
Definitely. I think that we have to be proactive going forward with this mandate from this new administration on environmental justice. We're not going to be sitting there and waiting for a crime to occur and then to go out and investigate it. We're going to try to get ahead of the curve, and we're going to do that through both community outreach, where people will inform us of what's going on, as well as data mining, so that we can find the violations in areas where communities are adversely impacted.
I want to come back to some of those notions like data mining and other things, but I want to bring Nadira and Stacy in, because you know, a lot of what we have been asked to do, Deborah, in these recent weeks is clients coming to us and asking us to translate what's been happening, right? And to sort of have them understand, is this a change? Is something going on here? And so, Stacy, Nadira, you know, how has this sort of come up in the context of your, representation, to the extent you can share, and what kind of guidance or advice are you giving clients, given the kind of things that Deborah is talking about?
Do you want me to? I'll go ahead and start,
Sure.
And then Stacy can follow. So yeah, it has come up quite a bit. So there's a lot of attention by the administration on environmental justice, and clients are receiving that message and are very interested in what that means. I think they have heard the message from Deborah and others, including the announcement by the Attorney General that enforcement in this area could include criminal enforcement. And I think that that's significant to them. And so I think a lot of the questions are in understanding sort of what that means, and sort of rejiggering their own kind of risk profile that they're using. And when they're assessing risk, understanding how factors that maybe they took into consideration previously, but they might have a bigger significance. What is the fence line community? What are the victims of a particular incident? And seeking to understand that, what are the impacts, the offsite impacts just of their normal operations, and understanding that sort of the enforcement that they may see, or the focus from regulatory agencies may be different. Will be different than what they've seen previously.
Yeah, Stacy, I know that a big, an important part of your practice is crisis management and helping people in that first 24 hours, first week. Does this add or amend that practice in some ways to kind of consider other issues or other considerations as you're helping clients work through those situations?
Absolutely, Steve, and great question. And thank you to you and to ELI for having me join the panel as well. One thing that is critical to crisis management is to anticipate the crisis. And so one of the things, because let's face it, there's going to be a crisis. And if you're not crisis managing today, you're adding to your future crisis. And so one of the things we've certainly said all along, or that I counsel clients on all along, is to get to know your fence line communities, have relationships with those people, already start engaging. And what, sometimes I get traction on that and sometimes I don't. What I would say is that this is a really, to the extent that there are clients who have done that, but not maybe done it as robustly as one would hope, this messaging from the DOJ and from the administration across the board is really driving that home. You need to know your community. You need to know how you're impacting your community. And if there's a good existing relationship, if an incident happens and there's a pre-existing trust with your community, you're going to fare much better. But I agree with Nadira. I think that those communities are going to, and I guess hinging off of what Deborah said, those communities are going to be leveraged to identify bad actors, or those that aren't paying enough attention to the externalities of their operations. And so I really do anticipate a heightened focus on this. The other thing I have been saying to clients all along, though, and this is a pat on the environmental crime section's back, is that I do think for a long time, as Deborah said, the section has been a leader in paying attention to its victims. And actually a leader in a couple other instances or areas that I think we'll talk about shortly. But this is an area where ECS has led. And so while I think the taking care of victims on the back end will not look different, using them to identify bad actors will be new and will lead to, I think, more prosecution.
So, I mean, Deborah, just to be clear, I mean, what you're talking about is, and I think that to Stacy's point, I remember reading even a decade ago, the crime section, the environmental crime section, talking, I think it was an article by Chris DeGay, talking about the notion of sort of enforcement sweeps, where you would look at an EJ community and then actually sort of look across that community at the regulated entities. I mean, having heard that, I guess I'm interested, is that the kind of thing we're talking about?
That's exactly one of the things we're talking about. When I mentioned data mining, that's what I was referring to, where you know that there's a community, there's a population there that's disadvantaged by this community, and there could be multiple sources that are contributing to the environmental pollution that's going on. So we would have to then do a sweep of these different facilities and try to figure out which one or two or more are the ones that are causing the problem, and then go after them in whatever way is appropriate to try to remedy that problem.
Stacey, maybe it's worth coming back to that notion, given the description of our panel, that what Deborah just described, isn't an alien concept to the environmental crimes program, right? I mean, can you sort of touch on the fact this is not going to be something that they're going to figure out for the first time how to do this sort of thing?
Absolutely. And again, this is one of the areas I was alluding to when I refer to ways in which I believe the environmental crime section has been a leader, and that has been being proactive rather than reactive with respect to enforcement, and really taking its national perspective to heart when it does its enforcement actions. Certainly there are U.S. attorneys' offices in the 94 U.S. Districts across the country that can handle the day-to-day implementation of, an incident or, I hate to say it, but your run-of-the-mill environmental crime. But ECS has a national perspective and has leveraged that really starting back in the 1990s with these coordinated efforts that are frequently referred to as national prosecution initiatives. And I don't dare say these are in order, so I'm disclaimer that they're probably not in order, but across the time there have been focuses on laboratory fraud, smuggling of ozone depleting chemicals, and then one that I think probably anyone that's done any environmental criminal prosecution has encountered, and that is the vessel pollution initiative, which started, I believe, in the 1990s, and for reasons that I guess are unclear to many of us, still feeds the section with some regularity. But you're right. This is looking across across a set of entities and finding similar violations and then going after them. So I think the section is well suited and well prepared to do this.
You know, Nadira, in your experience, both in the section as an AUSA and in private practice, you know, you've seen these kind of cases roll out over time. I noticed, as some of you may have, that there was a EPA Inspector General report fairly recently that came out, which noted that the enforcement program was limited by some significant resource constraints. And I did, as I was listening to, you know, Chandler's nice introduction of me, thank you very much. You know, when he said I had, you know, I supervise some 30 attorneys. I don't know how many it is today, Deborah, but it's not twice that. And you know, the number of EPA agents has sort of infamously, you know, kind of approached the statutorily required 200, but never quite gotten there, it seems like, and has declined. So, you know, I mean, Nadira, in your experience, you know, what have you seen in terms of, you know, sort of force multipliers or things that have been used to sort of expand enforcement in this space?
Well, so, you know, before I answer that, I was just thinking as I was listening to Stacy, you know, for a client, you know, for a company, the idea of these initiatives are sort of a foreign concept, right? I think it's hard for them to conceive of. They're used to thinking about their own operations and things that happen on their own, you know, in their own facilities. And the idea that there's some enforcement risk associated not only with what they do, but their neighbors or others in the industry is really a new concept and an unsettling one, right? I'm not saying that it's not significant and important from the government perspective, but I think from the regulated community, it's hard to know and understand what to do about that, and it requires some different thought. But turning to your question, Steve, you know, I think we've seen a number of different things that the government has done to sort of take advantage of other resources. And, you know, we see partnering with other federal agencies, be it the Fish and Wildlife Service, the Coast Guard, NOAA, FBI, Homeland Security, what have you. I think we might see, you know, as I understand what the administration is rolling out with regard to environmental justice and this sort of whole of government approach, I could envision, I don't know, but I could envision where those agencies that might sort of contribute to environmental criminal enforcement or have enforcement actions that sort of spin off of that might then include the SEC or the Federal Trade Commission, you know, other agencies that you haven't seen so much in the past. I think that's quite possible. So I think that from what I have seen when I was in the environmental crime section and as an AUSA, and what I've witnessed from the outside is that it's a section that's very talented and strategic about partnering with those agencies and, you know, sort of expanding the resources that can be brought to bear for some of the issues. And I think it's really important for the regulated community and for companies and individuals to understand that. I think also there are sort of state and local prosecution agencies, and there is a rich history there of partnering. And we have seen that. I've seen it on the defense side for sure, where there's been very effective partnership and use of sort of combined resources to bring very effective actions.
Well, Deborah, I mean, as Nadira went through that list, I'm sure you were thinking what I was thinking, which is, and then there's also OSHA. Because maybe that is the model and you really are the one who created it. So I think it'd be worth describing how that developed and, you know, how it got to where it is. And for our audience to understand the significance of it, let me just put it in these terms. Put your sense of, you know, politics to the side for the moment. Since the initiation of the worker safety initiative that I think Deborah's going to talk about, during this past administration, more than 8 or 9 times the number of cases that have been brought previously were brought in this space, because you had developed the program sort of below the radar, as career programs tend to be. So maybe talk a little bit about that, and maybe help us understand, is that a guide to what may be coming in the future in other areas?
That's a good prototype. This worker safety initiative actually began in 2003, and it coincided with actually a series of Pulitzer Prize winning articles in the New York Times and some other things that were going on in the section. But what happened was after 9/11, when all of the resources were going away from environmental, we were losing like our FBI partners and things like that for Homeland Security. We looked for a new work of agents to tap into, and OSHA, which had about 2,000 different inspectors in the very work sites that we wanted to police, we went to them and we started training what they call COSHAs, compliance officers for the Occupational Safety and Health Administration, to recognize environmental crimes, so that when they are out doing their inspections or responding to some kind of accident or fatality, they could, if they think there is something there, then hook up with EPA's Criminal Investigation Division and get an investigation started. And it was very successful. We actually trained hundreds, if not a couple thousand, COSHOs. We trained the solicitors who work for the Department of Labor, and we ultimately negotiated an MOU with them so that we were sharing information and sharing resources. But at the time that we started this, I believe there were 18 deaths a day in the United States, 18 workplace fatalities a day. And as this program was building, it got down to as low as 12 a day. And then over the last 4 years, it's ticking up again because there's been a bit of a rollback. But there, in addition then to looking for environmental cases, we actually were teaching them about Title 18 crimes, so that even if it didn't have an environmental nexus, these field agents were sort of empowered to realize that someone was changing an accident scene or lying to them or doing something that in some way hindered their ability to do their jobs. And so that even beyond environmental, they started doing more criminal prosecutions, for example, false statements or conspiracy or obstruction of justice. And that was the prototype. We've done this in other areas. I mean, we did a sweep in the renewable fuels area that actually was based on data mining. You know, there's reporting requirements under these programs, and went through it, looked for anomalies, and then went from there. So they can be very successful. And I think worker safety has been, as you said, I believe the year we started, there were 3 criminal referrals total in the entire year from Department of Labor, and now we have over 25 cases in the pipeline, plus the U.S. Attorney's offices are doing them, even though very often they're only misdemeanors.
So to Nadira and to Stacy, you know, when you hear this and when you're dealing with this, again, getting back to counseling clients, you know, what it seems like is the government is bringing together lots of different pieces that we used to think of as existing in silos, right? I mean, environment and OSHA, and maybe now environment and, I don't know, civil rights. I mean, in other words, you know, how does this, you know, how can you help clients in this space negotiate this sort of merging of these various paths that seem to be happening? Any thoughts about that?
You want to go first, Stacy?
Sure. Oh.
Sure. You know, Steve, I think this whole of government approach may be mirrored on the business side with the rising trend of environmental social governance that we're seeing. And Nadira alluded to this in referencing both potential future prosecutions by the SEC and the FTC. Really, as we are talking to clients and talking about how the whole of government is working collaboratively together, and that the health and safety have come together, you know, historically, now we are looking at environmental and civil rights coming in together, as well as other issues that are raised by environmental social governance. And so I think what I am counseling clients is not only do your business-wide environmental risk management or ERM assessment, but also really it is becoming more or less incumbent on companies to start thinking beyond basic compliance and thinking about risk beyond compliance. And that's really what the environmental social governance is about, is to think, what can we be doing more than what's just basically required of us? And if companies are doing that in a holistic, company-wide way, they are going to minimize their risks of worker deaths or false statements to the SEC, and actually push themselves to a place that's beyond compliance. That hopefully will, if they are doing it right and carefully, will keep Deborah and her crew away from their doorstep. But really do run the risk, as you are making these additional commitments, if you are making them and then seeking a benefit to your business from them, you are putting yourself at risk. So if you are saying you are complying beyond what's required of the Clean Water Act or the Clean Air Act, you need to ensure that you are following through. You aren't just saying it, that there are real commitments, that they're tracking that, and that you're ensuring that there is compliance with that. Otherwise, I envision that, potential next collaborations is between Deborah and the head of the SEC enforcement shop, or Deborah and the head of the FTC enforcement shop for what is referred to as the green guides, which are really what claims can you make about how green you are without crossing the line with the FTC. And, really there is a lot of drive nowadays to talk about an entity's sustainability and what it's doing, not only for the environment, but also for workers. And I don't just mean worker safety, but other rights and benefits. And so I think there's potential for Deborah to be working collaboratively, not only with the SEC, but potentially head of the Civil Rights Division, because of statements that companies are making with respect to how they are treating, whether it's their own employees or fence line communities. So I think there's, unfortunately, with every turn, with every sort of ability to stay forward and to stay compliant as the government thinks whole of government, there are additional risks that are created.
I completely agree. I mean, I think, sort of pivoting off of Stacy's comment about sort of the risk of sort of overpromising or purporting to be concerned about the environment or about racial justice, what have you, there's opportunity there and there's risk. And, this isn't true for every company, but by and large, one of the surprises I had when I moved over from the government to defending companies is the reality is I think most companies are pretty in touch with their communities. They are trying to do the right thing. They do understand and are trying to kind of not only meet sort of the letter of the law, but go beyond that as a general matter. I mean, it's not true in every instance, but I think it's largely true, particularly for more established companies. But I think part of the problem is it's they don't know you can have that commitment and be focused on those issues and still miss a lot because you haven't. You still, with limited resources, under the pressures of business pressures and everything else, you can misunderstand or just simply fail to recognize sort of brewing issues, brewing problems. You can fail to see events that may take place at your facility through the lens that the government now may be looking at it at, not because you don't care or not because you're sort of hardened to those issues, but just you were focused on, all of the other pieces, the regulatory, the obvious regulatory requirements. Right. And so I think reorienting sort of how companies think, there's a lot of work I think that we've been doing with companies and just sort of thinking more broadly about about where that risk is and deploying resources in a different way, and not getting ahead of themselves. So once you get on board, then not over-promising.
Right.
And one area I think that often is the richest for them to start is their own employees, right? Their own employees live in the community, and their own employees know the people who are impacted, and they have a strong sense of, sort of what some of the issues are. And so certainly that's one area we've been talking about, is enhancing those kind of communication lines.
Speaking of communication lines, and thank you both, Stacy and Nadira, for those comments. I just look back at our own slide and the words agency collaboration. And to a cynical Washington insider, that would be an oxymoron, actually, right? I mean, agency collaboration. And I think, and to Stacy's point, I mean, I think back to the chlorofluorocarbon smuggling efforts. Really, that began because Tom Watts Fitzgerald, the prosecutor down in Miami, discovered that there was smuggling happening, brought some cases, which people were not paying attention to. And what his cases illuminated was that Customs and EPA and IRS each had pieces of this, but they were not communicating. And I guess the question for you, Deborah, is agency collaboration no longer an oxymoron? I mean, it sounds like, your experience certainly with OSHA was that, yeah, actually there was collaboration and there was communication, and, maybe that, more cynical notion of how things work inside, the Beltway has changed somewhat.
I would say it's not an oxymoron, it's a necessity. And that is demonstrated in some of the recent prosecutions that we have brought. For example, within my own department, which is an agency, the VW defeat device case was brought with ECS and with the CRIM division, as well as the U.S. Attorney's Office, so that we combined our forces. And it was a good thing because the CRIM division has people who can speak German and read German and endless databases and things like that. It also has been happening in the RIN fraud cases that I mentioned. We very often have to partner with tax because there is a huge tax portion of these prosecutions, and you need approval to go forward from the tax division. So we might as well partner up with them, take their expertise, and we have double the counts that we would normally have because we're doing both the environmental and the tax. The same thing has been happening in the RIN fraud with securities. We've had some prosecutions after partnering with SEC attorneys because of the disclosures that they're making, both in their annual reports and specific certifications. And most recently, I think we're working more and more often with what's called MLARS, the Money Laundering and Asset Recovery section, because we have money laundering in many of our, I call them wildlife trafficking cases, but things that are coming from, let's say, fish farms overseas, and they're being mislabeled or illegally, harvested. They come to us, and the money's just big money is going around, and so we're using them, partnering with them on some of those cases, as well as, once again, in the RIN cases.
So Nadira and Stacy, I mean, like me, you guys, come to environmental crimes from more of a criminal prosecution background than just an environmental background. And I think one of the things we sometimes have to translate for clients is what Deborah just said, which is these are prosecutors. They're not environmental regulators, right? I mean, in other words, when we look at a case, when we're looking at a matter, we look at it just the way Deborah just did, which is to say, what is the potential exposure here? And it may be different than the regulatory issue. I mean, and Nadira, I know you've experienced that directly.
Yeah, I was thinking just that as I was listening to Deborah, that it's so hard for clients to understand. Like, they understand that there'll be enforcement. They understand that there's a role for criminal enforcement. But when they learn about an investigation, they're just trying to understand what is it that this prosecutor wants? What's bothering them? And how do we address it? And that's much more of a mindset for dealing with a regulatory, agency and attorney. And there's this presumption that somehow they can sort of focus in on what the prosecutor cares about. And it really is almost impossible for clients sometimes to understand this notion that there could be multiple charges in multiple areas, and that there's this idea that, you know, that the government is approaching it and sort of trying to get the most bang for its buck out of an investigation. It's very challenging. And I think useful for you, it would be useful, I believe, for companies and regulated industry to understand before they fall under investigation. Like, that's an unfortunate time to figure that out. And I think it would be helpful, I think, for companies to understand that more, and for DOJ perhaps to be more outspoken about sort of how prosecutions are approached, because I think it would, you know, it's useful to know, and I think it might impact companies' actions.
Right. And Stacey, you said, you know, the wrong time to figure, I mean, akin to what Nadira is saying, the wrong time to figure out how you're going to respond to an emergency is when you have one. And I think what Nadira is saying, the time to figure out the sort of broad, unimpeded scope of potential investigation is before you face one. And to recognize that you need a whole of company approach to address the whole government.
Absolutely, I agree, and I think you know, one of the things that I know that you and Nadira do for clients, and I do as well, is, you know, if you are going in and helping them build a compliance program, really talk about making them understand the broad scope of criminal enforcement, and understanding how little things that can happen within a company can take a situation where it really you know, feels like it ought to be a civil enforcement, to make it criminal pretty quickly based on a few decisions that are made that maybe at the moment, you know, considered individually might not bring Deborah and her crew in, but when looked at it in a whole package, really can. And so, you know, I certainly talk to clients about the fact that for the most part, criminal enforcement can happen based on knowing conduct. That although there really is an effort by between the crimes and the civil side to focus on lying, cheating, stealing, you know, that's all in the eye of the beholder, and really, you know, to think now, to get prepared now, as you say, and also to roll out training throughout companies as early as possible about the broad swath of criminal enforcement generally, not just environmental, but then sort of add the cherry on the top of the environmental because of the knowing versus intentional or willful.
Right. And I think, you know, based on what Deborah is saying, you know, clients often work from sort of these risk matrices where they're looking at, you know, what are the areas of risk I face? And those two sometimes can get a little siloed, right? And so this is a really helpful discussion, I think, in terms of understanding that, you know, a prosecutor like Deborah is not looking in a silo. It's looking broadly across the conduct to see whether it touches some other issues, as you just said, Deborah, you know, whether it may touch, you know, either a you know, financial reporting issue, or a you know, a consumer fraud issue, right? And that's what you're sort of referring to in some of these international cases, including VW.
Well, that's because there's a focus on victims, as it should be, and victims can be shareholders, or victims can be the consumer who ends up with the VW that has a defeat device. So that's why you're looking at the whole thing.
I was thinking too, Steve, that, you know, when you talk about these risk matrices, you know, I've seen a lot of them, and I don't think I've ever seen one that sort of is identifying whether or not the industry in which the company is operating in is the subject of an enforcement initiative, you know, or whether the community in which they're operating in is sort of likely to be a focus because of all of the other industries, or whether their neighbors are likely to bring just more attention by law enforcement or regulatory agencies because of their neighbors' actions. It's just not, and again, it's not because they don't care, it's just, it doesn't occur, it gets siloed.
Right, and the three of you know that I have made this sort of a stock part of my advice, which is that, you know, the government has this funny habit of saying what it's going to do and then doing that. And you know, if you're surprised if they do it, you know, I mean, obviously, you know, that's it is out there. And I think part of what all of you were saying is, you know, be forewarned, because the government is saying these things. I wanted to return for a second on the notion of victims of environmental crimes, because you said a few things, Deborah, that I thought needed a little more illumination. Because we're not used to hearing this kind of language in this space, I think it would be helpful to hear a little bit more about what you were just starting to get at, sort of what are the government's views of who are the victims of environmental crimes, and what are the harms that you're sort of trying to address or redress, if you could talk to that.
The harm is obviously physical harm, which in and of itself can be complicated, because if you think the physical harm is going to come from exposure to asbestos, it may not manifest itself for 30 or 40 years. Then there's the immediate physical harm for things like exposure to a pesticide or an explosion. So the physical will include not just restitution for whatever physical injuries, it's going to also include, in some instances, medical screening over the course of a decade or more, so that we can track what happens with someone's exposure to some toxic chemical of some sort. It's also, of course, property damage. Victims who have, you know, their home explodes because of a high pressure gas line problem, or the result of, remember in West Texas when the fertilizer plant blew up and destroyed much of the community, and things like that. I think it would even include illegal spills that go into someone's home. There is a component too of emotional damage, not necessarily with respect to restitution, because we are limited to what you can get under the restitution statutes. But with the new victim assistance program, I think there are some more tools to help people deal with trauma after an environmental incident of some sort, whether they've lost someone, lost their home, or suffered some other kind of PTSD. So those are the types of victims that we're dealing with, you know, the full gamut. What was your other question?
Well, the types of victims and the types of harms. I think you sort of touched on both things.
Oh, okay.
But you know, it raises a question, and it's a tough question for Nadira and for Stacy, which is, you know, when we think about and again, our remit here is, you know, past to present. You know, and certainly when I first started prosecuting, you know, organized crime figures for environmental crimes in New York, it was, you know, a guy storing tons of medical waste behind a high school, and things like that. When we're talking actually about what Deborah was just describing, we're not talking about someone disposing of something they didn't want, and not therefore, and externalizing the cost of that by passing it on to us, and often by passing it on, say, to an EJ community in some way and harming them in some way. We're actually talking about something happening that they don't want to have happen, an accident, right? An unwanted event, actually, which is painful, disruptive, and can be tragic. And when you're representing, you know, organizations in those situations, you know, how do you manage the sort of the understanding of, you know, is this actually a criminal case, or is it a tragic incident but not a crime, right? And just sort of, you know, trying to find the line between that, because I do think it's a different space than the one we sort of started out in environmental crimes. You know, the people intentionally getting rid of things they didn't want. But if your pipeline breaks, I mean, that is not something you want, right? you're losing product, you're losing business, you're losing opportunity, and you hope that's all you lose, because you could also end up, hurting people.
Indira, do you want to jump in, or do you want me to jump in?
Sure, I can start. No, I think that's exactly right. And, more important than how we draw the line sort of between Defense Counsel and the company is, how's Deborah going to draw the line, with her section of prosecutors, or how is the AUSA going to draw the line, and how they draw the line may be very, very different than how we might want them to or think is appropriate. And not because they're doing something wrong, but because I think there's a lot of room for argument and interpretation, in the language of those statutes and implementing regs. And there's not as much case law as we might want there to be to provide guidance. So, as you say, Steve, this is sort of an evolving area. And I think a lot of what we end up doing is communicating to clients sort of where the government might draw that line and what can be done to sort of influence that to some degree, to the extent one can. And I always say that, at the end of the day, whatever they may think, prosecutors are human beings with emotions. And, the more that, notwithstanding where they're going to draw that line, sort of the better equipped you were coming in, the better your compliance program was, the better you can sort of communicate sort of what efforts you made to avoid and what all your controls to avoid the event that happened and how you responded afterward, whether irrespective of, it just doesn't matter. If you're communicating those things, that is going to sort of influence to some degree where that line gets drawn, whether a prosecutor intends to or doesn't, it influences, I think, the discretion that's exercised. So,
do you agree, Deborah?
I agree.
A few things to say. I mean, one of the things I've noticed is that, after a traumatic event, that an explosion or something, there is a public cry for an investigation. And so very often the politicals who guide us, the political appointees who guide us, whether it's a U.S. attorney or someone in the Department of Justice, is going to push us to do an investigation, or it's going to be a letter from a senator or a congressman, something like that. And it's important to do these investigations, because even if they do not end up with criminal prosecution at the end, we have had instances where we learned what happened and we changed industry, because now that we know the root cause, it might not have been something that could have been foreseen. And it was helpful and it was worth it to do the investigation. So, yeah, we're human. I will say that.
All right, don't give her that. Don't give her that. That's very generous.
Investigation does not always mean you're going to prosecute.
Stacey, and if I just jump in, yeah. The way I have the conversation with clients is, the government's going to look at this and say, was this an accident, or was it an accident waiting to happen? And Nadira touched on that with how good is your compliance program, how prepared were you? And so when I talk to clients about an incident where clearly they've lost value, they've lost not only whatever product is now missing, it not only the fixing it, not only the civil lawsuits, but they've lost reputation in the community. But they really need to look at, could you have prevented this? And is that rational, something that could be enforced, or is that something that really nobody could have seen? And I will say here what I say to some clients is that I think the ECS is currently led by somebody that really is quite rational. Now on the next, if Deborah ever leaves, and I don't say that, everybody will wonder. But Deborah really, I know personally that she has made the difficult decision to decline prosecutions where it's not appropriate. And so I really feel like, and I think that's true throughout not only the environmental crime section, but there is rationality can prevail in U.S. attorneys' offices if a company really has done all the right things. Do I think it does? I'm seeing both Nadira and Steve smirk. Is
No,
it perfect at all times? I don't think so, but I really do think
right.
that there is a lot of attention paid to what measures were taken to avoid this, and or what things were not attended to that directly led to this.
Right, and I think, you know, what your comment underlines is the difficulty of, you know, continuous improvement. You know, you referenced the notion, I think, of beyond compliance, and really what I think you mean is continuous improvement, because compliance is sort of the thing in the horizon that you're moving toward, but we are not only prosecutors, but the rest of us are humans too, and we make mistakes. And you know, what you don't want is a system where post facto considerations of would have, could have, should have replaces sort of one of the bedrocks of criminal law, right, which is fair notice. And the notion that I can get up in the morning and I can figure out actually where the line is between behavior that, you know, would be considered, you know, appropriate and behavior that would be across the line into criminal, and then, you know, govern myself accordingly. And, you know, one would hope that you would do it in the way that, you know, Justice Brandeis did when describing the criminal provisions of the Antitrust Act and saying, you know, you can walk right near the edge of a cliff, and then if you misstep at all, you're going to fall off, right? But if you step a little bit away and give yourself some space, then you have some, you know, you have some leeway to do that. You know, we had a question from the audience, and I do want to be attentive to that, about how decisions are made, since it's right where we are, Deborah. And ultimately, who does make the decision on whether to go forward? Is it the EPA or is it DOJ? And I won't give my usual discussion of the word client right now, because you all know what I think. So go ahead.
It is definitely DOJ. I mean, we have relationships with EPA agents who bring us the cases and work on them, but they are well aware that the ultimate exercise of discretion is going to be the prosecutors. So it's a DOJ decision, and it's generally made at the line level. I mean, the trial attorney who's investigating the case will decide whether to push it forward to what we call a prosecution review. And at that point, it's going to be looked at by a committee of attorneys, and they're going to decide if it's something that the group as a whole thinks should go forward. And there are levels above that, but the decision usually is made within, I'd say, our section, or in a U.S. attorney's office. You know, you don't get any higher than the crim chief unless it's just a big notable type thing where there's a lot of public attention. So it's DOJ.
Thank you. And another
Steve,
question. Oh, go ahead. Sure.
One thing I think people need to watch out for, though, is there are, depending on the U.S. Attorney Office, there are U.S. Attorney offices where they don't have a relationship with environmental crimes section, unfortunately, and they don't have a lot of enthusiasm necessarily for bringing an environmental case, but that doesn't mean they're not going to pursue it. And sometimes you find yourself where it really does feel like EPA or the agent is calling most of the shots. And so I think it is important to recognize sometimes when you're in one of those jurisdictions, because it's the rules are very different then.
And I would note, I see that happen a lot. And the savvy defense counsel is going to, if you really think it's going off the rails, it's going to bring it to the attention of the AAG through the DAG's office, so that you can maybe get more rational people looking at it. And that's something that I would suggest you do if that happens to you.
We got a great question, and one that I hadn't anticipated, and I thank this person for it. We've been talking about victims, and we've been focused on a lot of the things you talked about. From the view of your section, what about wildlife, and what about the environment itself? Do you view that as a victim, in effect, of potential victim of environmental crimes, whose interests you're seeking to vindicate.
Very much so. And with respect to the environment, we used to, in every plea agreement that we could rationally fit it in, have a community service payment, at least in, when we have a plea agreement with a business organization, a corporation, so that we could actually directly remedy the harm that had been caused by the violation. That was essentially the only way that funds were going to go there, given that all of the funds that we get from all of the penalties that we get go to the victims fund, which is more victims of violent crimes, and it doesn't go to anything environmental. So we do that with wildlife crimes. Let's say with domestic ones, there would be restitution to the state because they are the owner of the wildlife, and we make sure that that happens. With overfishing in the Great Lakes, for example, a lot of money went into the hatcheries to try to replenish those stores. And with respect to our animal welfare practice, we actually treat the dogs as victims. That's been litigated. I was surprised, but we very much, we have the dogs forfeited, we get them the medical attention that they need, and then we get them new homes. So down to the little animals, we treat everybody as a victim when we can.
I think Nadira commented on this, but maybe just to confirm that based on one of these questions, that the section doesn't just do cases with EPA, and and obviously we've talked about Department of Labor and Coast Guard, FBI, and I mean basically you'll work with anybody.
We will. Department of Defense, Department of Transportation, Department of Agriculture, which gives us our dogfighting aid, lots of OIGs. And most recently, one of our strongest partners is now Homeland Security Investigations, because they're interested and they're willing to do the work. And I'm very pleased with the way things are going with Homeland Security.
What is the nature of the kind of case we're talking about, or you can't say? I mean, I'm fascinated.
No, I could say they're very involved in the illegal logging. So things that are coming in that have been, taken illegally from Russia or Brazil, the logging, they're interested in that coming into the country.
And just to be clear, there's a question that you were not. Well, I'll ask the question. Were you encouraging Defense Counsel to sidestep U.S. attorneys' offices to get a second bite at the apple at ECS? And I don't think that's exactly what you were saying, but.
No, you can't really sidestep the U.S. Attorney's Office, because when you go to the DAG's office, they're going to require that you've been all the way through the U.S. Attorney's Office up to the U.S. Attorney. What I'm saying, if you have a really off the rails type thing going that is just not consistent with prior practice or with the norms that you would expect, there have been instances when you can appeal to the DAG, who will then involve the AAG, who's a political appointee, and you might get a remedy that way. And I know that question came from Tom Watts Fitzgerald, so anyway,
Well,
no,
he would never say that. Tom would never say that.
I'm not saying bypass at all. I'm just saying that I have seen instances when what's going on in the U.S. Attorney's Office, it's just unheard of.
I want to move forward to an area that we talked about amongst ourselves quite a bit. And Stacy, maybe you and Nadira touch this off and see what Deborah thinks. But one is that those of us particularly involved a lot in representing folks in the energy industry have seen the rise of private equity in that industry in areas that are heavily regulated, and sometimes creating surprises for them about some of the issues that can arise in investment in that space. And then the fact that we, as a country, have some, aging energy assets, some of which may be impacted by either moves to renewables or other things. And maybe Stacy, start with you this time on sort of how these issues you think are playing out and how they relate to the conversation we're having today.
Happy to jump in first, Steve. And actually, one of the things as I was listening to Deborah say she'll work with anyone is that I think one of the agencies we didn't mention is the Department of Interior, which I think could be highly relevant and could become a really close partner in the coming years, particularly for offshore aging assets. There is certainly, as I've seen it already, a push to close up some of these retired wells, offshore wells, and actually properly close them to ensure that they're properly and safely closed. I think that will obviously pertain to on federal lands, within the onshore as well. But you raise an excellent point. I think these are areas that have been largely overlooked in the enforcement scheme thus far. I know of a handful of enforcements in the aging assets area. By and large, they are administrative, not even civil, much less criminal. But I anticipate that as the requirements are, I anticipate that there will be, enhanced regulations that will require enhanced compliance and enhanced focus on how to retire these assets. And so it really, I think one of the things, if you're in this industry now, is to pay attention to the rulemaking process to make sure that you are engaged there and now. Again, crisis management starts today for a company, and because there's nobody that better knows how to close one of these assets than the companies that are involved in it, and what it takes and what the realistic expectations can be. So, with respect to aging assets, there's the focus there. The role of private equity in this industry, I think, is going to become, more and more interesting, and it really will maybe dovetail to the question you were talking about earlier with respect to, or maybe I said it. Was it an accident or an accident waiting to happen? I was so smart.
Right.
Anyway, private equity, I think there's a really important role for private equity here, but they have to be mindful in how they get involved and to ensure that they, as private equity, are not stripping the operating entity of the funds to do what they need to do to ensure that they can be in compliance and can ensure that not only in compliance but can do the sort of the constant moving forward, as you said, Steve, staying with not only the critical obligations, but ensuring that as you're looking at the tail end of an asset, the last thing you want to do is put more money into it. And yet that may be what you need to do in order to avoid an asset, to avoid a real incident. And so the questions that private equity will be facing vis-a-vis funding, I think will grow. And there are, I think that there will be instances where, Deborah's office may be hiring somebody that understands, or maybe they already have it, somebody that really understands corporate structure and how the funding lines run, because there is, I think, if done properly, a real positive role for private equity, but an enhanced risk if done for the private equity entity if not managed properly.
Before Deborah responds, let me ask you, Nadir, because I know that you have worked on behalf of private equity clients, particularly in the energy space, in both offshore and onshore. So I'd be really interested to get your views on this.
No, I really agree with what Stacy had just said, and I think that it will be helpful and useful as private equity can play a very important role, and I think there's often sort of a scheme, not a scheme, but a setup in which the private equity has some kind of third party who has care, custody, control over the operations and taking responsibility. And when an incident happens or an event takes place, it can get very murky, and I think there's certain expectations that private equity have that are all sort of grounded in corporate law about sort of where, what their exposure is.
Mm.
And I think, a question for them, for the government is whether or not those are accurate, right? And sort of how the government does see that role, and whether or not there's sort of a focus or an initiative that's, focusing in on the role of private equity, and what will the rules and measures be. And I think there's probably, if there isn't now, I think there will be intense interest in that area to sort of hear more from the government.
Well, we could hear more right now.
We'll see. How about that?
Yeah. Okay. Well, I guess we've talked about this before too. I mean, just the notion that, really fits into what you were saying, which is you don't look at these issues in a siloed manner. You look at what comes to you. And as these issues, as Stacy said, proliferate in terms of the management of these assets and the control of them, it seems likely that it's something that may come to your attention.
Yes, I would agree with that.
I encourage folks, if you do have any remaining questions, to get them in. One of the things that in the time remaining we have just to turn to is this notion of what we once called next generation enforcement. And I think, you sort of touched on it, Deborah, when you talked about data mining and sort of the more sophisticated use of information. So, and maybe just touch on that again for a second. I mean, I guess, I think it was Stacey just said, have you hired someone, or do you have that resource to do that kind of analysis when you're dealing with massive amounts of data or information that you're trying to get through to figure out what you're actually looking at?
We need more resources, but the point is that global commerce is built upon disclosures. For example, if you're importing wood, you have to make a declaration to customs. If you are operating a vessel that's coming, I'll put that on silent. If you're operating a vessel, you have to make entries in an oil record book that's presented to the Coast Guard. And so you're foreign flagged, you're foreign owned. And then another example would be if you want to sell diesel cars in the US, then you have to get a certificate of conformity from the EPA. So you're always making statements and declarations. That's our jurisdictional hook. So one of the ways to look at that is just to go through the disclosures that are being made and finding out where the anomalies are. Like I said, data mining, and we could use more resources. Those are actually agency resources. For all of EPA, they only have one analyst. I think that they're going to really have to staff up in that area. The most effective I've seen is with Customs. They have quite a lot of resources there and information to go through. But it is very important in moving forward with investigations. It's one of the best ways of being proactive, is to be able to find where something looks like it's amiss and then investigate.
One of the things that I think people may know or may not know is that actually OSHA began using drones to conduct site inspections several years ago. This was done permissively with the consent of the employer prior to using the drones. OSHA has since requested what I think is called blanket authority from the FAA to operate drones in airspace across the country. And I am hearing, or some observers in industry are saying, that they expect not only OSHA to use drones more frequently, perhaps without employer consent. Does EPA have a policy on drones, and can they never use them? Can they possibly use them? How is that playing out?
EPA does have a policy. They are not authorized by statute or regulation to either own one or to lease one, but they can work in conjunction with other agencies that do have the technology. The thing is, they have to have permission from the assistant administrator, and the immediate past one, Susan Bodine, my understanding is she did not believe in using them. So they are looking to update their policy right now. It remains to be seen what happens. But I do know that Coast Guard has some drones, and that's going to be very important. I don't know if they have the right technology yet, but we now have MORPOL Annex 6, which is dealing with the emissions, the air emissions from ships, not just the oily water emissions. And I think one of the only ways that we're going to be able to detect these violations is if we have a drone with a sniffer on it that can go out and find the violators.
Didn't you say before that you have a workplace safety initiative with the Department of Labor? And if OSHA is using drones and you've trained people at OSHA to look for environmental violations, I think there's something called the plain view doctrine or something like that.
Yes, I did say that. So it's amazing the use that other countries are making of drone technology, and we're not. For example, in Poland, they're using them to find people who are exceeding air emissions. In Italy, they're using them to find where organized crime groups are dumping hazardous waste. Even Nigeria, Indonesia, and Pakistan are using them to find marine pollution. And Brazil is using them to find illegal logging, because it's so remote, or illegal mining or illegal fishing, and we're not. So I think if we want to keep up, it's going to be important to change our policies and to get some resources.
On the issue of data mining, my friend Bill Laufer at the Wharton School at the Zicklin Center has done a lot of great research on the issue of data and the access to data as a vehicle for controlling, corporate crime from his perspective. But I think, Nadir and Stacy, it also sort of presents a challenge for clients as to whether they're adequately using their own data to identify risk, and whether that is something where there's an opportunity to better identify, potential risk before it ripens into liability.
I agree. I mean, I think there is data there to be mined, to be understood. And, when we're talking about previously these risk matrices, et cetera, data is certainly a mechanism that can be used to better understand. But first it takes recognizing what data is relevant and incorporating it in. And I think that's and an understanding of the enforcement landscape. And that is so often the disconnect. And it is, I think it's, again, I think it's unfortunate when a lot of the communication around what the enforcement landscape is solely being communicated by defense counsel, right? I mean, I think that's a place, but that's very late in the game.
Right.
The only thing I'd add to that I found interesting actually over the past 15 months is that as companies were struggling with how do they do their audits, how do they continue to do their audits, with particularly in the early months, I actually had conversations with clients in which they said, hey, can we be using our data that way as opposed to having to go out and do physical inspections? And initially I said that if you can't get out and do a physical, that's certainly the next great option. And your question really suggests, I think, a good answer to that, which is now that we've done it, let's do a yes and. And it may very well be a great first step in what a compliance audit looks like for a company, is to do their own data mining. The one other point I wanted to make on this next gen, which has sort of come up a couple times in my mind, is fence line communities also have this next gen capability. And I think that is something that we have to keep in mind, is where cases can come from. It can be from community groups that are using their cell phones that now have capabilities that are, that are actually potentially forensically sufficient, and if not, are at least adequately sufficient to cause an EPA agent to be interested in a case. Likewise, neighbors can be using drones to be, videotaping and the like. And so just a reminder that this next-gen compliance is not necessarily only in the hands of the entity or the agency, but I think it really brings third parties into play here as well. And just Nadira, I think as you've been saying all along, I think it's just a further complication, making running a business even more complicated.
Right. And so I guess what you're saying is that's a part of your, before the emergency planning, is to consider these issues, right? And to also, I mean, you know, one of the ways I do like to think about it is you've gone to the expense of actually generating data. If you don't mine it, you're sort of wasting some of that money in some ways.
Absolutely. Yeah. What are you doing it for? And if it's there and the agency has the capability to look at it and assess it, you ought to. And if you don't, it really can't cost that much to do it, because we all know the agency doesn't have that much money to do it. I mean, as Deborah said, they only have one analyst. So at this point, really, companies should be able to stay ahead in doing their own analysis. I think really, going back to Nadira's point, there's nothing ill will about having not done it before. It just was never really contemplated. And making it, just as we continue to get better and as entities continue to get better at environmental compliance. I will also say this is something we talk about, you know, companies talk about in the context of environmental social governance, right? They start looking at what's my water consumption or what's my air emissions, and then it may be fully compliant with their permits, but they realize if they do 2 steps, they're using less water and they're saving money, but that's also good for the planet. And I do see a lot of drive and interest in doing that. And so I see a lot of possibility to use this data mining, not only for the benefit of avoiding criminal enforcement or civil enforcement, but also for the betterment of the bottom line and the environment.
Data can also be used as currency, you know, to resolve a matter. And there isn't always the appetite on, you know, for a certain company to do that. But I mean, I have certainly seen recently, I think with all the recent attention in the civil context and even potentially in the criminal context, some interest around sort of what data a company accumulates and what they're willing to sort of monitor going forward and what they'd be willing to make available publicly. And so, you know, it's an interesting way to see data as well.
Yeah. I mean, and I think, you know, and again, our remit of, you know, past, present, future, you know, certainly years ago when the section was attempting to undertake certain kinds of work, you would have to go to a government contractor who had the capacity to do the computing. That level of computing, as Stacy said, might be on my phone today. And so, you know, it as the pace of that dynamic data capability increases, it increases, I think, the pressure to be ahead of your own data, which is what Stacy and Nadira both been saying a lot. In the few minutes we have remaining, you know, the arc of this, you know, discussion has sort of started with ways in which the government may initiate new kinds of investigation, either by, you know, engaging with EJ communities, using other kinds of data or information to actually start cases. And now we're sort of coming to the point of saying, okay, at the conclusion of a case, what kind of things might we be looking at in the future? There was a lot of communication about the issue of, in the civil side, supplemental environmental projects and the policy in that space, and whether they were allowed or not allowed, and that is still going through some process. But again, sort of quietly on the criminal side, there has been a long history, right, Deborah, of the use of, you know, what we're calling community service payments as an add-on to, or as a remedy or an additional, you know, aspect of the resolution of criminal cases. Where are we on that now, on that continuum?
Yes, it's been a long time program at ECS. It's been incredibly popular with both the corporate defendants and with the U.S. attorney's offices and everyone else. And I think it did a lot of good. In June of 2017, the first prohibition came down, and it was a memo from AG Sessions that prohibited payments to non-governmental third parties who are not victims or participants in the litigation. And that in itself had 3 exceptions, one of which was payments that directly remedy the harm that is sought to be redressed, and they specified environmental harm. That was then codified in the Justice Manual, and it still exists there. But December 16th of 2020, some midnight regulation came out that we didn't even know was in the works, 28 CFR 50-28, which is the same thing from the Justice Manual, the prohibition on the payments to third parties, non-governmental third parties, but it took out that exception for environmental altogether. And one of the things that's going on is with the new administration coming in, all of the memos that dealt with this in the division were withdrawn. So there had been several of them on the propriety of these types of payments. They were all withdrawn, meaning what's left is that regulation, which, as I said, it prohibits payments to non-governmental third parties. So one of the things, the thinking going forward is that before the reg came out, we were able to treat payments to congressionally chartered organizations like the National Fish and Wildlife Foundation as they're not non-governmental, they're governmental. They have to report to Congress. And they're the ones who can directly redress the harm. They had the ability to do it, and that seemed to be okay with the AAG at that time. I think in reaction to the prohibitions that were getting more and more stringent, Congress in 2020 actually amended the NIFWIF's Establishment Act and authorized them to receive and administer restitution and community service payments. They built that into the statute. That to me means they intend on payments like this to be made. So I believe that we're waiting to see what happens with that regulation. I don't know if or when it will be withdrawn. And until then, we're going to have to be very cautious going forward. We have not done a community service payment out of my section, and I can't tell you if a U.S. Attorney's Office has done one either in over 4 years.
Okay. Do you think that will stay that way or change, or you just don't know?
I hope it changes, but I can't predict because I'm not in that circle of trust. So I don't know what's happening.
Well, there's some advantages to that too. You know, there are other things that we talked about that, you know, probably are worth having further discussions on. I think that, you know, the June 2020 memo from the criminal division about what constitutes an effective corporate compliance program was a really fascinating document, and I'm sure plays a role in your analysis of cases, Deborah, and certainly plays a role in our assessment. And, you know, looking at resolutions of cases, you know, one of the things that certainly, as you know, I've had experience with and others have as well, is the use of monitorships, and whether that's something that you would be looking at more in the future. Is that something that, as a remedy, is something that you are still considering as a viable outcome?
It's definitely a remedy that we will continue to consider. I don't think we'll consider it any more than we used to. Nothing's changed with respect to us. The memo that did come out with respect to monitorships in the crim division is not binding on us. And we actually do things differently than they do. We always have it as a condition of probation as opposed to part of a DPA or an NPA. Therefore, it's got some, you know, the judicial approval. I think that in certain circumstances, they are absolutely necessary. We do them almost routinely in vessel pollution cases. And one of the reasons is because we're dealing with a vessel that comes in, but they've got a whole fleet of vessels that we want to make sure that they're doing the right thing all the way through. I see Chandler's come back, so but we will continue doing them.
Well, listen, Deborah, Zadira, Stacy, thank you all so much. Chandler, thank you for putting this together, and thanks all of you who listened. I hope you found it useful, and I appreciate you spending the time with us today.
Thank you, Steve.
Thank you.
Thank you, Steve.
Thank you. I echo all of that. Just want to say thank you so much to our audience for joining us today and your many thought-provoking questions. We hope you'll continue to watch this space in the years ahead. And an enormous thank you to our amazing panelists. We just really, really appreciate your contributions to today's program. Thank you all again so much. Please take care and stay safe.
Take care.
Thank you all.
Bye-bye.
You too. Bye-bye.